Can you see it or do I need to swap view?
You need to swap view. It's the PowerPoint view.
How about now?
Yeah. Oh, yeah, they're good.
Okay. All right. Work through all of that. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of Wills and Advanced Legal Planning, Part 2, How to Draft Your Own Will and TODD or a Transfer on Death Deed. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and today is Friday, November 14th. I actually have Thursday on there. So thank you all for joining us this afternoon for this presentation. We have today joining us who will be presenting the information on how to draft your own will. And TODD is our partner with Lone Star Legal Aid. And representing today, we have Ms. Jessie Campbell. Also included in our partnership, we have the Earl Carl Institute, Harris Central Appraisal District, the City of Houston's Department of Neighborhoods, the Harris County Tax Assessor Collector's Office, Lone Star, I'm sorry, Texas Legal Services Center, and Houston Volunteer Lawyers. And together we make up a month of service. And just to give you guys a quick little brief, a month of service is a collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops and resources and information to the communities that we serve in regards to asset building, asset protection, the maintaining of generational wealth, and community empowerment. And in that series is the Wills and Advanced Legal Planning. We've had to divide this part up into two segments. The first part about advanced legal planning is why do you need it? The second part, which you're here for today, is how to draft your own will and TODD. There's a lot of information that's covered in both presentations, so we thought it'd be a good idea to kind of break it up so that a little bit more time can be spent specifically about giving you the information on how to create and how to draft your own will or your own TODD. So, but of course, we do invite you guys to come back next month for the first part of the segment if you want a little bit more information about all the other documents that make up an estate plan and why do you need them. And then Jesse's going to go over all that more information up about that in just a moment. But again, we decided to collaborate several years ago in an effort to create a larger impact, to reach more people, and to get as much information out to the communities that we serve by pooling a lot of our initiatives and our programs together so that we can offer them collectively to the community. So this platform has allowed us the opportunity to reach people outside the city of Houston, throughout surrounding counties and across the state of Texas. So do know that regardless of where you're joining us from, if you are in the state of Texas, that the information provided is relative to the state of Texas and not just for the city or for Harris County or anything like that. Also note that this is your opportunity to ask whatever questions that it is that you have for the presenter who is an expert in this field. But do know that we are on a public platform and we want to try to protect your privacy as best as we possibly can. So we ask that you try to keep your questions to be as general as you can keep them so that we don't get any of your personal detail information out there for everybody to have access to. In addition to that, that the information that we do provide is for educational purposes only. It is not to be considered any legal advice. And you're going to hear that again when Ms. Campbell gets ready to start her presentation, just as a reminder. But again, do know that this is your opportunity. We do encourage you to reach out to our legal service partners if you do find yourself in need of any civil legal assistance, and do not automatically discount yourself and assume that you don't qualify or won't be able to. I'm sorry, I was trying to admit more people won't be able to qualify for services. So we do encourage you to apply for those services when you find yourself in need. But again, we want to thank you all for joining us this afternoon. We're kind of a little bit out of order this month due to a scheduling conflict. Typically this presentation is the first Thursday of each month, and then we go into the second segment. Each month we rotate each month, but however the second Thursday of each month is the part that happens after probate, what happens after someone passes, and that's the clearing title and inherited property presentation that we actually did yesterday. So if you guys need more information or have probate questions, then feel free to watch that presentation from yesterday. But we do hope that you all receive the information that was intended. We are in the planning phases for 2026, so we do ask for your feedback. Following this presentation, there'll be a quick a link that pops up for you to complete a survey. We would definitely appreciate your feedback and letting us know how you enjoyed the presentation, if it was helpful or beneficial, or if there are other presentations that you'd like for us to present in the future that you'd like more information about, then please let us know. So that will definitely help as we are planning for 2026. But with that being said, again, a lot of information is going to be covered today. So without further ado, we're going to jump right on into our presentation. Please feel free to type your question into the chat. Miss Jessie is really good about kind of answering as she goes along. But in case there are some questions that you do have that we don't get to, we will go back and listen and ask those questions in the end. As well as if you emailed me in advance, I will be typing those questions into the chat. If you are joining us on our social media platform, you will have the opportunity as well to type your question into the comment section, and I'll make sure that your question is addressed at the end here too. So you will be able to access part one later. Part one of this presentation was done last month, so I'll include the link from part one's presentation into the presentation for when I send out the recording. The one from yesterday, um, the clearing title for inherited property, I can include that link on that presentation as well for you to go back to see. However, if you did register for that one, then an email of that recording did go out yesterday as well. So with that being said, Ms. Jessie, let's go ahead and get into it. And yeah, just get this information.
All right, thanks to that. Good afternoon, everyone. My name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid. And, oh, excuse me. That's a great way to start. Drink real quick. Um, And today we're going to be talking about how to draft your own will and transfer on death deed. As Ms. Nia said, that we do have part one, which is kind of the bigger scope conversation. It talks about what is estate and advanced planning, why you need it, and all the different types of documents that you have. Today we're just talking about two of those documents, which is the will and a transfer on death deed, if applicable. We will talk. You will see that not everyone needs a transfer on death deed, but it's and but otherwise, I would recommend that if you haven't watched part one, that you go and take a look at part one, or come back next month when we will be doing it again. But let's go. There it goes. So a little bit more about Lone Star Legal Aid. We are a legal aid program in the state of Texas. We cover civil legal aid. So pretty much anything that you think of that is on a legal matter that you would think of that affects the individual, we kind of handle that. So consumer, employment, family law, public benefits, estate planning, and probate, which is what I'm talking about today, and has just an example of a few things. We don't handle criminal cases. We also don't handle personal injury cases, and that's just a couple examples. There's some other things that we don't handle, but they're little, they're specific to those individuals who have those issues. Our service area covers 72 counties in the eastern and Gulf Coast region of Texas, and 4 counties in southwest Arkansas around Texarkana. So the eastern third of the state of Texas is under our service area. We have 14 offices, including the headquarters in Houston, which is where I am located, as well as all those offices listed throughout our service area. Eligibility is based on income and the size of your household. I wish I could tell you that I can give you a number and that makes you then you will know for certain if you're eligible, but it's actually pretty complicated mathing that we have to do. And it takes a bit. We gather quite a bit of information from you to be able to determine whether or not you are eligible for services. But don't believe that you may not necessarily be eligible for services. Again, it depends on how much your income is and the size of your household. And so if there's a possibility that you're eligible, we do encourage you to apply. This can be a very overwhelming process of drafting your own documents. And if you qualify for services, we may be able to find you an attorney that can draft them for you. Can't guarantee you one, but we may be able to do that. But today, really, we are going to be talking about how to draft your own documents. So that way, for those of you who are not eligible for services, or you have a more urgent need, you may have received a prognosis, or there's another reason why you feel really driven to get your will and transfer on death deed completed. Today, we're going to be kind of giving you the tools that you need to be able to do that. Today is for educational purposes only. I am not providing legal advice today. Today, I'm going to talk about the forms and how to complete it in a very general level, but I can't provide legal advice unless and until you are eligible for services. So please be mindful of that as you're asking your question. I can't answer specific questions about a specific situation, how to draft for a specific item that I cannot answer today. So just, but also, as Ms. Nia said, we are in a public space. The internet is forever. So don't put anything into a comment, whether you're on Zoom or watching this on one of our social media sites, that people can find information and use that against you. So please be aware that this is a public space, and we do not want you sharing personal and private information that other people have no business knowing. So, but also as you're kind of looking at the questions, if you do ask me a very specific question, which I guess I do discourage, I will only be able to answer it from a high level and not address that specific issue, but I'll do my best. As Ms. Nia said, I do pretty well at answering questions in the chat as we go. And so if you have a question, do that. If you prefer to ask the question verbally, there will be time at the end. And for those of you watching on our live streams and one of our social media sites, someone will be monitoring the comment boxes there, and we'll ask those questions at the end, or if possible, they'll get typed into the chat, has depending on it. But just be aware, those of you watching it on a live stream, we will have time at the end to circle back to those questions. All right. So our agenda today is we're going to take a few minutes to talk about how to choose your representative, and then we're going to talk about what the types of wills are, whether or not the pro se documents work for you, and then how to complete those pro se documents. And pro se is basically representing yourself. That's all that means. Then we'll talk about transfer on death deed, and we'll quickly do an overview of what the other advanced planning documents are, so that way you can know what else there is out there. For part one, that's a link to our YouTube channel where you can watch it. But of course, Ms. Nia said that she will include that in the email as well. Okay. Choosing your representative. In this case, we are talking specifically about the executor. That is the person named in the will. And what is it is that you're picking a person who will be acting on your behalf when you're not able to do so due to death, which is what we're planning for when we're talking about a will, or incapacity, which is some other documents that we will not be covering today. But all of these documents, that whatever they're called, in this case, an executor, what we are doing is someone is stepping into your shoes. They are handling your affairs on your behalf or on behalf of your estate. And so when you're selecting someone, you want someone that you know and trust and will do what's in the best interest, or as you would do in that situation. And so this may or may not be the quote unquote natural choice. When we're talking about the role of an executor, it's work. Like it's things that need to be done. It's going to court and doing whatever and working with an attorney with the court to probate a will. In many instances, there's other exceptions, like there's other things that need to be done, but something has to be done, right? We have to do the process of going to probate court, selling the property, preparing the property for sale, or drafting the documents needed to transfer ownership from the person who's passed to the beneficiaries under the will. So there's things that need to be done. Final tax returns, if a person is still working, and final tax returns have to be filed. So that's kind of the responsibility of an executor. It's kind of taking care of all those last affairs that need to get handled, paying bills and collecting money if money is owed to the person who passed. So when you're thinking about that, right? So it may not be like who you think of, right? Like it may not be your adult child. adult child may be able to do it. A lot of people do choose family members to do this role. There's nothing wrong with that. But it may not be your adult child. Maybe the best person to do it is your cousin who's an accountant and really digs on paperwork and really has the ability to kind of handle that, right? And so just kind of keep that in mind because you're asking someone to actually do something that takes quite a bit of time. It's, you know, estate administrations vary in how in the length of time, but like the average is around 9 months to a year to do all of that because of just it just takes time. It takes time to get all that stuff done. And so some are shorter, some are longer. But you're asking somebody to kind of take that commitment on to be able to do that work. And so just kind of think about that, right? And just as important when you're picking a person, you also want to be sure that you have discussions with the person that you're not picking, that natural choice, right? You may have an adult child who the eldest is like who's already stepping into the mantle of being the patriarch or matriarch of the family, and and they're thinking, oh, that's going to be me, right? But then you picked your cousin Bob, and you're like, well, no, I picked cousin Bob. Well, let your child know, right? To be able to say, hey, I understand that you want to do this, but this is a loving decision for you, from me. It's a lot of work. I went to this presentation. This woman named Jessie, she, said that I gotta work. They gotta work with a lawyer. There's paperwork. There's, we gotta do negotiations with sellers, with the buyers of the home, make sure we get the best price. And it's like, and you're gonna be grieving. We're best friends. I know I'm your best friend and you love me, but you're going to be grieving, and I don't want you to be buried in paperwork when the best person to handle it is cousin Bob, who's an accountant, and and this is going to be his gift to you and to me to make sure that y'all are able to focus on what matters, which is learning a new life without me here, right? So to have kind of those conversations with people so that way, because when you're no longer here to explain why the decisions were made, people will create their own stories in their mind. I'm like, oh, did they not trust me? Was I not gonna be able to do it? And so just kind of keep that into account when you're thinking about who you're selecting and then having conversations with the people around that. And and explaining that it is a loving decision. If it is your oldest child, by all means do that, right? But if it's not going to be, if it's not going to be your spouse and things like that, right? Like have these conversations, talk it out, make sure that everyone is on the same page, so that way no one is feeling wounded and hurt feelings that can never get resolved. And so we do recommend that you select one person. I do get clients who are like, oh, I do not want my children. I'm fine with one of my children doing it. They understand what the responsibility is, but I want them to have equal rights to it. I want them because I don't want them to think I love one more than the other, or I trust one more than the other. There's a favorite, like I get that. I completely understand that, but I heard another attorney in another presentation describe it this way. Do you want two people driving a car? You probably don't, right? So this is again, there's a lot of decision making that has to happen. If there's any family conflict in terms of like who's going to get what in terms of the personal property, the executor is the person who's going to be the one making the final decision, resolving those family conflicts, and being responsible for doing the next step. And when you have more than one person, there's potential conflicts that can arise from that. And then what's going to happen? You may get standstills. You may end up with a situation where the judge is going to be like, I'm the one that's going to decide what to happen here because y'all can't come to consensus. And now you have a person who doesn't know anything about your family dynamics. Making a decision. And this is not a slight against any of our probate judges. We have wonderful probate judges. But it's still personal, right? Like these are things that are very personal, and you want people that you trust to be the ones who are going to be making those decisions on behalf of your family. And when you do select your executor, go through the document with them. Even this pro se document that we're going to go through, and kind of explain like what you chose here and there. And like, so that way, if there are any questions, they can ask you and be like, hey, what did you mean by that? Right. And they'd be like, okay, now I understand. You mean grandma's diamond ring, not grandma's emerald ring, right? And so, and then of course you're going to have an alternate. Just there are reasons why the first chosen person is not able to serve. They themselves may have passed, they may have moved. There's other reasons, time, constraints. There's a lot of different reasons why the first person that was chosen may not be able to serve as the executor. So you're going to have an alternate, and you're going to have the same conversations with your alternate that you did as your primary executor. All right, so let's start talking about a last will. So what does a will cover? This is one of those things that's easier to talk about in the negative, like it's basically what is not covered versus what's covered. So non-probate assets. So this is the difference between a probate asset and a non-probate asset. A probate asset, by its legal definition, is basically the property that is handled by the probate court in a probate proceeding. I mean, that's really what a probate asset is. So we're talking about, so when you have a non-probate asset, these are property that's held in such a way that our folks in Austin or folks in DC have said, hey, when you own property in this way, it's not, it can pass automatically without having to go through the probate process. That's what a non-probate asset is. And so for most people, it's one of these four types of accounts. Retirement accounts, those are IRAs, 401ks, 403bs, those types of things. You're going to go to the financial institution where those accounts are held, and you're going to complete a designation of a beneficiary form. And so then and you'll do that. Life insurance proceeds, you're going to contact the life insurance policyholder, and you're going to complete a designation of your beneficiary there as well. And for our bank accounts and our savings accounts at banks and credit unions, you will do what is known as a payable on death account, and you would designate a beneficiary there. So for all three of those, we're going to talk about those three first because those involve designating a beneficiary. So how does that work when you do that? The beneficiary will contact the financial institution where these accounts are held. They will complete whatever paperwork is required at that stage. Usually it's some type of a form and submitting a death certificate. And then those institutions will do what is necessary to transfer the accounts over, whatever those policies are. They will get explained to the beneficiary on whether it's a check being written or a new account being, a wire transfer, like however that account is going to work. It's really important to think about your non-probate assets. So because they don't pass under a probate proceeding, they pass outside of probate. You need to be sure that those are up to date, right? Like be sure that the beneficiaries are who you want to be listed there, because the court will never, assuming that there's a beneficiary and they're alive and they're going to inherit, right? The court's not going to be involved in what happened to the property when there's not a beneficiary, when there's a beneficiary listed. So you want to be sure that those are up to date just as much as when your will is up to date. And so I usually recommend that you update those, look at those and update those on a regular basis, pretty much the same time when you're kind of reviewing your will, and making sure it's up to date. The payable on death account for your checking accounts and your savings account is really a good tool. That's available for many, many people. The major property that they have that would be subject to probate will be their house, their car, and their bank accounts. A lot of other things that may not necessarily have to go through the probate process. Personal property, sometimes you can just, there's may not even be a need to file anything if all that needs to be handled is probate, is dealing with the personal property. But I've had so many clients come that apply for services to probate a state where the only asset that we are trying to get is a checking account. Banks will not accept affidavit of heirships to, to be able to pass on the account. So that is something that if you are coming today because you're thinking about how can I avoid the probate process or minimize the probate process, the payable on death account for your checks and savings account is really a very useful tool, and that will be able to help your heirs be able to have access to it. You still are an account holder. You can do whatever you want with it. They don't have access to the money until they file the paperwork and then the property is transferred. So that's a kind of a really good resource for you to keep in mind. We don't talk about that because it's a form you complete with your bank. So you just go to your bank and then make sure that you get this put in place. The fourth type of a non-probate asset is a joint tenancy with a right of survivorship. This is not the default. The default in Texas is an undivided interest. So, for example, when you buy a house with your spouse, the two of you own and the two of you own what is called an undivided one-half interest in the property. So you have a you own 50% of the property, but you have access to 100% of the property. And so there's a misconception that when you own property that way, that your spouse is automatically going to inherit the property. In some instances, that would be correct, that the spouse is the person who will inherit it under the Texas laws when a person passes without a will, but that is not the default. If you are married and you had children from a previous relationship, even though that house is community property, even though you and your current spouse purchased it together, if there's children from a previous relationship, they will inherit the 50% that is owned of that property. And that may or may not be what you want. I'm not here to tell you what to do with your property. I'm telling you how to make sure what you want happens, right? And so, but that's the default. When you buy a house, that's the default. You can create property with a joint tenancy with a right of survivorship, where it's guaranteed, where the person who survives, and this will come into play in the joint, and when we talk about transfer on death dates, that the person who survives owns that property, and then they can do whatever they wish to do with it when they pass, right? I always say that think hard about that. It's much easier to create a joint tenancy with a right of survivorship than to undo it. And so there can be some unintended consequences. And if you're not sure if this is the right path for you to move forward, I do recommend, if you can, to go speak to an attorney about that. It's pretty rare. I rarely do that as part of my estate planning process, where I recommend people to convert property to joint tenancy. There's a lot of ways to create what you want with a will that's properly well written and well and executed, that can solve that will affect what you really want to do with your property. And so, but that's something to kind of consider. Otherwise, everything else is a probate asset. So if it's not a non-probate asset, it's a double negative, right? So then it is a probate asset and it'll be governed by the will, right? And so again, just a reminder that you want to be sure that any of your non-probate assets are fully up to date. All right. Types of wills. There are two types of wills in the state of Texas. One is a holographic will, just legal language for saying that it's a will written 100% in your own handwriting. This cannot be delegated because the key part is your own handwriting. So you do need to be able to take out a piece of paper and a pen, write out your will, sign and date it, and that is a valid will in the state of Texas. It's optional and don't encourage to have two credible witnesses over the age of 14 to witness the will. And then a self-proving affidavit, which is you're signing the will with a notary, which you and your witnesses are signing the will with a notary present, and they are notarizing the document. Highly recommended because it does make things a lot easier, but not required to make it a valid will. Then there's an attested will that's 100% typed. So you can pull out your computer, or if you're old school, a typewriter, and you can type it out. There's no hybrid wills, no fill in the blank wills allowed. You see there's an asterisk there. There may be an exception for the Supreme Court forms, which is what I'm going to be talking about today. Those are fill in the blank forms. And there does appear to be in its instructions an exception to the no hybrid wills and no fill in the blank wills. However, it does not actually follow what the law actually says. The law actually says it has to be one or the other, either 100% handwritten or 100% typed. And so the recommendation that I tell my clients or people in general is that if we're going to be using the Supreme Court forms as our pro se will, that you should complete the form on your computer, and then when you print it, it will be fully typed, and that will be guaranteed to be in compliance with the law. And so that's just kind of my recommendations. For a typed will, it is required to have two witnesses over the age of 14 to be able to sign that. They have to be disinterested, which means that they are not a person who will benefit from the will, nor have any interest in the estate in order to be able to. So who are good witnesses? neighbors, friends, coworkers, people that can come in and be able to do that. Optional is a self-proving affidavit. What is a self-proving affidavit? It is an affidavit signed at the same time, you and your two witnesses in front of a notary, and the notary will notarize that with the affidavit attached to it. And so why does this matter? Because it makes things a lot easier when it comes to probate. When you have a handwritten will, you're going to go to court and you're going to say, here, Your Honor, I have a handwritten will. The judge is going to say, okay, I need two witnesses to come in to testify to the handwriting of the will. And so I don't know about you, but very few people I know who are disinterested know my handwriting. I type most things to most people. I may have some college friends that may, when I write them their Christmas cards, that they could be able to identify my handwriting. But for the most part, how many people actually know what your handwriting looks like and they can testify to the handwriting? And so it is recommended that if you even are doing a handwritten will, that you have witnesses. Because what happens when you have a witness, when you have two witnesses for either your holographic will or your 100% typed will, which is required to have two witnesses, when you go to the court and be like, here, Your Honor, I have a witness will, whether it's typed or handwritten, and the judge is going to say, okay, I need one of those witnesses to come in and testify. But they're testifying to having watched you declare that it is your will and signing the will. So they're not saying that the signature is their signature or it's a handwriting sign. They're saying they're testifying to the event of executing the will. And that's one person. And you have a second for a spare, but also it's required. They're required to have two witnesses. So there's the spare. So you have to bring in one of those people. And so why is the self-proving affidavit an optional but highly recommended if you can do it? Because it removes the witness requirement. Your Honor, I have a self-proved will, either handwritten or typed, and the judge is going to look at it. It's going to see it's been properly executed, and the judge is going to say, okay, the will is now admitted. So it removes the requirements for the witnesses. And so that is why we recommend it. The pro se wills we're talking about today include the self-proving affidavit and has instructions on it to go sign it with a notary. And so those are our types of wills. If you're in a bind and you don't have time to do anything, you can write it out by hand. But when you have the options available to you, then you're going to bring two witnesses and you're going to work with the notary on that. All right, so pro se, again, all that means is that you're representing yourself. And these are forms that have been approved by the Texas Supreme Court. So this is our Supreme Court that sits in Austin. And you can find that at that website, which is txcourts.gov/forms is where you are able to find them. And but we will also share the link with you in the email. There's 4 different forms. One is for persons who are single, widowed, or children, and who have widowed or divorced, who has children, married persons who have children, and then the single version, and then the no children versions of that. A person who is single, widowed, or divorced and does not have children, and then a married person who does not have children. For all of these documents, they are in English and they have a Spanish version as well. Okay. Here's the question. Can I use the pro se forms? Pro se is not always the best option for people. And so you kind of need to think about whether or not you want to use these forms in your situation. Things that take into account family matters and family members and dynamics. Are there people who are being disinherited? You can disinherit people. We don't have that in the will. There's certain language you want to include in a will when you're disinheriting family members, or if there's conditions. Sometimes there's a condition that people would like to put into the will. What type of property is owned? We need to kind of consider. Is there a house, personal property, antiques, family heirlooms? We kind of want to take into account like what the property is owned and what we want to do with it. That will probably also impact whether or not you can use a pro se form. I already got to be thinking about who is inheriting, because do they have special needs or considerations that we need to take into account? People living with a disability and they're receiving government benefits based on income, that has some specific needs when you're planning on if they're going to be the beneficiary. There's things that you, as the testator, as the person writing the will, that you need to kind of take into consideration when you are writing when they're inheriting. Are they under a guardianship, an adult living with a disability who has a guardianship for them, a minor under the age of 18 if they're inheriting. There's things that we have to kind of take into account. Is there debt owed, secured debt, a mortgage or a reverse mortgage, car loan? That can impact whether or not you do that, because some of this stuff does not get discussed in a pro se standardized form where they're really trying to think of what most people would need, but not necessarily what individual needs are. And so that's kind of the difference between them. Are there special instructions? Are we going to be creating what is known as a life estate, where a surviving spouse gets to live in the property for the rest of their life, but upon their passing, the house goes to children from a previous relationship, or for example, or something else, right? Like, so there's things that you would kind of take into account for special instructions. That is when you would be recommended to go speak with an attorney, and make sure that that will is drafted in the way that to affect what you want to happen to your property. And the pro se documents may not actually be what you need to make sure it happens. Okay. All right. So let's start talking about the forms in and of themselves. So as you can see, on one side is my notes, and then the other side is a screenshot of what the forms look like. And so I'm just going to go through each section and kind of let you know. So every single one of those wills, whether it's married or single, section 1 is the same, where you're going to put in your full legal name. This is your legal name. This is what's on your documentation. But you're also going to want to include as known as, right? Like, so some people have a legal name, but they go by something else, an alias that they've used in their life, or previous names, right? So you want to be sure that you include that information. It 1.2 is basically saying this is my will, and you're revoking any previous wills. If it's a married form, you'll be 1.3, which will say who you're married to, and that it's a reference to spouses to that individual. And if it's a form requiring with children, then you will have the 1.4, which where you're going to name all of your children. And there's a chart of just basically a blank table chart where you're going to list the name of your children and their date of birth on the document. And so that's section 1, the identification. So this is the married form. And so this is everything I own except the specific gifts, right? So this is the I'm just giving everything to one person type of thing, right? So option 1 and choice number 1 is that you give everything to your spouse if your spouse survives, right? And then if the spouse does not survive, then everything to my children except for the specific gifts, which is a different section. So this is a residuary clause or a complete clause where just like this, I know everything's going to be going to my spouse, and if my spouse doesn't survive me, it's going to go to our children. And so that is what this section does. Okay. And obviously, if it's single with children, there's not going to be a question about the spouse. And it's, and if there's no children, the children are excluded. There's a different thing for the children. So then you would skip to section 3. You would skip to section 4 if that's it. You don't have any specific gifts. All right. And so this one is everything that you own for your separate property plus your half of the community property, right? So this is a different choice. So this is where we're not giving anything to our surviving spouse except for the specific gift. So option 1, everything to my spouse, children if my spouse doesn't survive me. Option 2, not my spouse, my children only, right? They're going to get everything under option 2. Does not matter if the spouse is surviving or not. Again, if if everything is being divided into situation, then you're going to skip to section 4. It's really important to know this. This is no instructions, right? So if it's everything to my kids and there's 3 kids, each kid is getting a third of the estate. You can't put in the instructions here on what, it's like, well, I want this kid to get this property, this kid, right? You can have verbal conversations with your children and be like, this is my expectations, but there'll be no legal force to that. So, when you have these conversations and you assume that like that's going to be what's going to happen, well, your children are going to do what they're going to do to either follow your advice or do whatever they wish to do in that sense, and redivided separately among themselves. But this is, they get equal shares. So no differentiation here. Okay. And so this is the single, widowed, or divorced, which is everything you own, then you're going to list the people, right? If you're single, there's no spouse to list. If you have no children, then you have no children to list, right? So that's going to be how the forms look different versus married versus single. Same thing if everyone is being getting everything and there's no specific gifts, you're going to skip to section 4. And so now we have section 3, which is the specific gifts. All right. So there's some different categories here, right? So first one is your home. That first section is going to be your home. I give my interest in my home subject to mortgage and liens, right? So anyone who inherits the property, they inherit it subject to the mortgage or reverse mortgage. They gotta pay those mortgages in order to keep the house. And so, but that's going to be what this first section is. You're going to list the person who's going to get the property here. All right. I'm going to cover this again when I talk about transfer on death deed. This is really important for everyone to hear. If you also do a transfer on death deed for your house, the transfer on death deed takes priority over the will, which means that if in here you give your house to Susie, and then you file a transfer on death deed giving the house to Bob, Bob gets the house. You do a transfer on death deed to Bob, and then you write a will giving the house to Susie, Bob gets the house. The transfer on death deed takes priority over the will. And the only time that the will come into play is if for some reason the transfer on death deed is voided out and never happened. But we assume that the transfer on death deed will stay effective, and this will not, and your whatever you put in your will not have any impact on that. So just keep that in mind. So, but that's the first part of section 3, specific gifts relating to your house. Then we have specific gifts related to personal and household items, right? So this is kind of where people are splitting things up, right? So section 2 is like everything to a person, right? Except for these specific gifts. And this is where we're kind of pulling things out a little bit separately. So this is our personal and household items. So, right, one person is receiving the home, and then another person is receiving the personal and household items. But in this one, it's everyone listed is going to get it equally, just like in the section 2. So every person is going to be needed. You don't have to put any kind of specific items in this one. That's the next block. But if there's any disagreement, so there's 2 kids who really want grandma's diamond ring. Well, the executor will make the decision on who gets the diamond ring, right? So that kind of goes back to that conversation on when you're choosing your person, right? Those are decisions, conflicts, whether or not they're fighting, right? It's a conflict because who's going to get it? The executor is the one who's going to be having that power to make that decision. And then lastly, so you have section 1, which is you have the first part under section 3, which is our house, second part, which is the personal items and household items, and then part 3 under section 3 was your specific items, right? This is where you're going to list grandma's ring, right? And so like, all right, grandma's diamond ring is going to go to Susie, right? That's where you're going to list it. And you're going to want to be specific about that, right? If grandma happens to have 2 diamond rings, you're going to want to be sure you describe the 2 diamond rings, right? Grandma's engagement ring, grandma's 25th anniversary ring, right? Like, and hopefully your children, the people know which one's which, right? And the same thing, you want to be sure that the name of the person is also obvious on who it is. There's a running joke in my family, which is that everyone is named either John or James. You walk into a room, you yell, James or John, half of the men in the room will turn around, right? And so, right, be sure that we got the right, which is the right James, which is the right John, right? That's going to be getting the property. And so, so while it says the full middle and last name, you're going to write that, right? If there's a possibility there's another person that's a similar name, you can also write, son of Bob, right? Is who we're talking about here. And again, very similarly, if there is any kind of conflicts here, or that we're not sure what's going on, executor is going to make that final decision. So section 4. So that's basically it when it comes to what happens with the property, right? And so kind of think back to when I was talking about like the non-probate and the probate assets and like whether or not these forms work for you, that's very limited, right? That's an extremely limited thing. What you will notice is that none of that talks about a life estate. right? None of it has instructions. There's no one, there's nothing there about, you know, the first, I want the kids to inherit the house equally, but I want the first, $10,000 to go to Susie because Susie replaced my roof and that's how much it cost her. So I like her to get the first $10,000 back. And then the remaining of the home gets split between Bob and Susie, right? Those are all, can you do that? Sure. You can always put a specific bequest of $10,000 to Susie for the purposes of repaying, if there, but that would be if you had $10,000 that you can give her, right? Like, but if you wanted it from the sale of the home, that's not gonna like there you can't put those instructions in there. That's going to be something where you need to go and write a will with those specific instructions to ensure that it does what you want it to do. And that's just one example. There's lots of other things. The other thing you notice it didn't take into account a person living with a disability who's receiving government benefits. Inheritances from can impact a person's eligibility for a government benefit that's based on income. And so there's things that you would need to do. There's instructions that you can give to ensure that the person can inherit the property, but still be able to protect and retain their benefits that they're receiving. And so none of that's going to work here. Because just kind of looking at how very straightforward these sections are. Like it's blank. Whatever you list, if there's three people, they're each getting a third. So just kind of keep that into consideration on when you're looking at this will. But for a lot of people, this is gonna be fine, right? A lot of people, their will really is, if they're married, everything to my spouse, and if they don't survive me, to equally to my children. That's a very common will that I write. Like, so it's common. So this may work fine for you, but I just want you to keep that in mind that if there's something that is unique and different, it may be better to actually go have a will written for you that's specific to your individual needs rather than try to shoehorn it into a pro se document just because a pro se document is available. All right. So section 4 is the independent executor section. And so this is just standard language that we're going to be putting in there. Sorry, I just skipped the executor part, right? So you're going to name your first choice and your second choice for the executor and the third one. Remember, this is that person you're picking to stand in your shoes to do all that work associated with handling and managing the probate estate. And so just kind of keep that in mind. The requirements is that the person has to be 18 years of age or older, and the court must approve. So if there's a reason why the court cannot, it's rare they don't disapprove the choice. But if there's a reason, the court needs to be able to approve that person. One of the things that historically would disqualify an executor was if there were a person with a felony conviction. That law has recently changed, going into effect in 2025. Now a person with a felony conviction can serve as an executor if specifically named in the will to serve as the executor. So that's an example of when someone can be disqualified. There's other things that can disqualify someone that's very specific involving crimes or abuse, those types of things. This is appointing an independent executor. And what does this mean? That the executor, can do all that work without court oversight. And so, if it's a dependent administration, there's court oversight. The court has to approve the sale of the property, has to approve the paying of the debt, right? Like, so those are things that can be required by the court to look at it. Whereas an independent administrator or executor is like, they can do what they need to do. All they have to do is provide the one required court document at the end, and then that will be all that is needed. Again, when the way this is written, it's only one person serving at a time. There's no co-executors in this case, which is good because we only want one person driving the car. Additional language is giving the instructions on what the executor can do. 4.2 is that my executor can serve without a bond. What is a bond? It's an insurance policy. If the estate is mismanaged, then there's the bond to help cover the costs of the mismanagement. But since you're picking a person that you trust and that you know will be working in your best interest, you don't need a bond. And so you would required for there to not be a bond. And then 4.3 is basically instructions to the executor to handle the estate, pay the debts of the estate, sell property if needed, basically do all the work that the will is asking you to do. And then 4.4 is saying that though action can be held in the court, again, that independent type of thing, other than the ones required by law, which is probating and recording of the will, notice to beneficiaries, and then filing any required inventory document for the estate. There is a section in the children's, when there's a children associated, when it's custodian for people under the age of 21 who will inherit. Generally, minors cannot own property on their own. There needs to be some kind of a trustee or custodian managing that property until they reach the age of 21. And so that's what this will says, 21. So if you want something different, 18 years old, 25 years old, you can't use this document because remember, there's no hybrid wills, right? So you can't just like cross one of these sentences out and write your own thing. Because even if a fill in the blank will is allowed with the Supreme Court forms, the only part that's going to be considered part of the will is the part that's the blank, the court inserted blank. But remember, you're not going to do that. You're going to take your computer out. You're going to complete this form. It's a fillable PDF on your computer. You're going to print it for it to be fully typed, but you're not going to be able to go in and cross out anything here. Like this, that's why it's a template. This is why it's a form. So if you have a difference of opinion in terms of age, this would be a different thing, right? And so, but basically, this is following a pretty, what is called a Uniform Transfers to Minors Act, which basically means that this is kind of like a standard act across the United States, not just Texas, where we kind of like, this is what happens when minors inherit property. In this case, it's saying that the executor can serve as the custodian for that property, and it can be the surviving parent, but is not required to be the surviving parent. And the executor may also appoint different custodians for different beneficiaries. And the executor themselves can serve in that role again. Again, this is only in the forms for children. And then it's the guardian of a person of a minor or incapacitated adult. You're going to name who the guardian is going to be. Who's going to be taking care of your children if they are minors or if there's a guardianship for an adult living with a disability. This is a separate process, right? So you're basically naming the person, your first choice and your second choice, and then there's a different court proceeding to name the guardian. This is not a dispositive list, which means that the court is not required to appoint the person that you name. The person does still have to be eligible to serve in that role, but as long as they are, then the court will name the person that you have listed here. Section 7 is laws. Texas law applies in survivorship. So every state has its own laws as it relates to probate and estate planning. So if you have property in another state, I can't tell you what to do there. Our transfer of death deed or our will have no bearing on the property there. So you have to make sure that you're doing your estate planning that complies with the state laws in that state to ensure that the property is going to be. Maybe our will can do it, right? Some states will allow you to go through the probate process in Texas and then submit that documentation to that other state of the will being probated here in Texas, and then vice versa. The will is probated in another state. You come to Texas to do the work that needs to be done in Texas for that property. But you do need to but realize that we are talking about Texas law today, not any other law. And so this section is just making it clear that Texas law applies in this will. And then 7.2 is saying that before a person can inherit, they have to survive for 30 days. This is trying to avoid complex probate problems, right? Unfortunately, sometimes people pass at the same time. There's an accident and one person passes, another person has some injuries, survives a few days, and then passes. Without a survivorship clause, there would be two probates happening in this case, one to transfer the property to the person who passed afterwards, and then another probate for the person who passed second to pass the property that way. What this does is that if the person doesn't survive the 30 days, so they pass on day 10, then they don't inherit the property. The property will pass as if though that individual pre-deceased that they passed first. So that's basically what a survivorship clause does. It does have it for 30 days. If you wanted to be shorter or longer, you would have to have a different will that drafts it. Right. Then we're talking about the execution, attestation, and the self-proving of the will. And so remember, two witnesses. So this section you're just writing. This is not the signature. You're going to print your name and the names of your witnesses. Remember, they have to be disinterested, so not receiving or otherwise benefiting under the will in any way. So who are good witnesses? Your neighbors, friends, and coworkers, if they will be willing to go meet up with you later to sign this with the notary. And then with the notary present, you're now going to execute the will. So this is the section where the testator, that's you, the person writing the will, is going to sign and date it. And what this you're saying here is that you are saying this is your will, that you willingly make this will. There's no duress. There's no one forcing you to do this, that you're doing it in front of the witnesses, and that you ask the witnesses to be there, and that you are now signing it in their presence. That's what that section says. And then once you sign that, the note and the witnesses will sign the will, then the notary will complete the process. There's a notary block. They will verify you and your witnesses, ask you some questions, and then ask witnesses questions, and then they will sign and seal and finalize the will. Just a quick note, not all notaries will execute a will. You cannot go to your UPS store and execute a will at a UPS store. They will not do that. Some banks with their notary services will do it, but not all. So just be sure that when you are working with a notary, that you call them before you show up with everyone. It takes a while to gather people sometimes, and just make sure that they're willing to notarize a will. That being said, as part of the AMOS, the Month of Service Partnership, NRCDC, Miss Nia's organization, does assist with executing pro se wills. And so you can always contact them to find out when those dates are scheduled, and then you can show up and and you can execute your pro se will with the notary there. Okay. So what do you do next? What do you do with this will? First, you're going to staple the will. And once you staple it, you're not going to unstaple it. So you cannot do any kind of thing that's kind of a destruction of the will, because that can invalidate the will. So when I say that, we're going to, there's no no hybrid wills. Like as soon as you cross out a line and you're like, oh no, I want that survivorship to be 90 days. You cross out that 30 and write a 90, that can be considered a destruction of the will, depending on how the court interprets that. So, one of the things could be the taking a part of the will, right? And changing things out. So once you staple it, you're not going to unstaple it. And be sure your executor knows that when you're giving them the instructions. When you work with my organization, we provide written instructions that we include, that we have you put in with your will, for the executor to know what to do with that document when the time comes. If you need to make copies, just don't unstaple it. Make copies. You can make copies of a copy. Just be really careful about making sure that we don't accidentally destroy the will and the integrity of that will. Copies are not valid in the, they're not valid wills. So you do need to be sure that the original will is kept safe. And that is what the executor needs access to when they go meet with the attorney and when they go to court. So just kind of be mindful that. Plus, I also don't recommend that people make lots of copies of the wills and give it out to a bunch of people. You only want to make a copy when it's absolutely necessary. But you want your executor to know how to get to the original will. So speaking of that, where do you keep your will? Does it need to be in the safety deposit box? No, not necessarily. You can put that in the safety deposit box if you want. But just keep this in mind. In order to get the will out of the safety deposit box, the person has to be an account holder, and they must have a key in order to be able to do that. Otherwise, if they're not an account holder and they do not have a key, then it requires a court order, and only the executor can take the will out of the box. And so, and if there's no will in there, the executor cannot take anything else out of the box. And if they're not the executor requesting it, they also cannot take the will out of the box. So keep that in mind when you're going to use a safety deposit box. But otherwise, where should you keep it? In a safe space. It's easy, not easy for people to get it easily, but where your executor knows it will be. Um, I've had questions about putting it in a freezer bag and putting it in your freezer. I'm not a big fan of putting any kind of important paper around moisture. So, even in a freezer. So I don't recommend that. Where do you keep your important documents? Where are your passports, birth certificates, social security cards, right? Those are important papers. I would just put them with your important papers. Some people can, we happen to have a safe in our house, like a document safe, and that's where ours are. But you don't have to have one of those. You can just put it in the desk, and then let your executor know where all those documents are. So that way, when the time comes, they can find it easily and do what they need to do with it next. Um, and then, of course, I already talked about making sure that you have instructions for your executor to know where the will is, tell them do not unstaple it, and take a will to an attorney when the time comes. And that's really important, right? You've done all this work to write your own will, to make sure that your estate's going to get handled the way it needs to get handled, and then your executor doesn't do anything. Well, that doesn't do, right? So you may not need to do anything. I mean, there's a possibility that there's no probate required, but you want to be sure that there is. Like, the longer you get away from where a person passes away, the harder the probate process can be and can make it very difficult to clear title to property down the line. So you want to be sure that the instructions are to the executor, hey, this is where my will is. Be sure you don't do anything, don't write on it, don't unstaple it, don't do anything to it. And then you're going to call a lawyer and bring the will to the lawyer's office. And then the lawyer will ask questions to talk about what's needed in the administration of the estate, and then they'll prove forward on the next steps, whether or not a probate is required. All right, so that's it on the wills. It's pretty straightforward. I mean, these are very simple wills that meet a lot of people's goals when it comes to it. And if that works for you, fantastic. But also remember, individual plan. You got to take into account who's inheriting the property. Are we disinheriting the property? Are there special needs we need to take into account? Are there instructions that we need to give? If you have any of that, if you feel like you're trying to force the gift and the instructions in there in some way, go consult an attorney about drafting a different document that meets your specific needs rather than trying to force it to happen in these pro se documents. We'll double check real quick if there's any questions on the will. I do not see any. So now let's
Nope,
talk
not
about
yet.
oh, not yet. Okay.
Nope, not yet.
Okay. So now we're going to move to the transfer on death deed. I'm going to apologize right now. This can get very confusing because of the way the document is set up. I'm going to do my best to break it down in a way that it makes sense and that you can follow along, but the document is written in a way that makes it a little confusing. So you will get a recording. It's an hour into it. So if all you need to do, you can go in and rewatch this as many times as you need to if you are drafting your transfer on death deed to make sure that the form you are using, if you are using the same form, that you are completing it correctly, because it is unfortunately for some people, including myself, you'll probably hear it when I go through this, that it can be a little confusing. So what is a transfer on death deed? It's commonly nicknamed a TODD, right? We like acronyms around town, right? It's a way to transfer real property, land and house, to someone else when the homeowner dies. It is automatic. The only thing that needs to be done is a registration of the death of the person, and then that's it. The house is automatically now owned by the person listed in the TODD. Um, what's good about this is that, remember, those three things that people typically own that require probate, which is your bank account, which you're going to have a designation of beneficiary on that payable on death account. So you're going to take care of that for your bank and savings accounts. Or if you have a retirement account, you're going to name your beneficiaries on your retirement accounts. And then for our car, there is a transfer on death document for our cars. It's a designation of a motor vehicle. So you can complete that and for that, and then you have your house. And those are the three things for probate, and a transfer on death deed will help. And so you have all of that in place. You can very potentially avoid the probate process altogether unless there's conflict, unless there's another need. There's money owed where there is negotiations that happen, right? That's why the executor needs to go talk to an attorney to make sure that a probate isn't necessary. But if we're thinking about that very base level of why we're doing these documents, is to try to make it as easy as possible for our beneficiaries. And we have a situation where we can do these documents and they are the right documents to use to kind of keep, that to be able to do that. Again, as a reminder, this takes priority over a will. So if you gave your house to Susie in the will and then you do a transfer on death deed to Bob, Bob gets the house. It does not matter when the transfer on death deed was executed and filed versus when the will was executed and drafted and executed. And so just kind of be aware of that. If you change your mind about who's going to inherit the property and they are listed on a TOD, you will need to revoke the TOD or draft and file a new transfer on death deed. You can only pass the portion that belongs to you. So community property, that's 15% of your joint owners, the percent that you own, right? So sometimes like 3 children will inherit a property. You can only do a transfer on death deed for your 1/3 of the property that you own that you inherited. And so kind of keep that in mind. Even under a transfer on death deed, you still inherit the property subject to the mortgage. And the beneficiaries will be responsible for paying any mortgage or lien against the property. And so keep that in mind as part of that. Let them know, oh, there's a mortgage or there's a reverse mortgage on this property. I go into quite a bit of detail on this when I talk about it in part 1 on like how to navigate debt. So if you have kind of questions about like, well, how do I deal with debt, mortgages for this property? I do recommend you go see part 1 because that one I spend more than 2 minutes on kind of discussing what happens when there's debt at the time of a person's passing. So pro se TOD, again, pro se, self-representing, you're drafting the documents on your own. You're not hiring an attorney to be able to do that. There is a transfer on death toolkit that's prepared by the Texas Access to Justice Commission. It's available on a website called texaslawhelp.org. There's also an online form with that kind of lengthy little conversation there where you go in and you answer the questions online, and then it will print you a transfer on death deed at the end of that. The day we're going to be going through the toolkit because that's the paper version of the transfer on death deed. This you can do by hand if you wish. You're going to see it in some ways that maybe typing makes more sense, but this you can actually complete it by hand, not a worry. So this one can be a hybrid, half written, half typed. All right. So part 1 is you're going to name who owns the property, right? So that's it. It's your who owns the property and the mailing address, which may or may not be the property address, right? So if there's more than 2 owners, then you're going to add another sheet with that name, right? You're going to add an appendix basically, and then list the same information to that. Okay. Section 2 is by far the hardest part and the easiest place to get to make a mistake, which is section 2 or number 2 is the legal description of the property. This is not your mailing address. This is the, the 34th division, lot B, section 3, it could have meets and bounds potentially, and that's going to be kind of like from the 34th degree, blah, blah, go 40 feet, another, right? So that's what the legal description is. So you need to look at your copy of your deed that you have when you purchased your home or inherited the home. Hopefully that has your full legal description there. And that is what you're going to write into section 2. Some people will ask about their property tax statement because there is a legal description on that. That is not also sufficient. A lot of those legal descriptions on your property tax statements are reduced because those descriptions can be lengthy, and so it cuts it down to the main information that you need. If for some reason you've lost your deed, you can look it up with the county clerk's site, or go down to the county clerk and ask for a copy of your deed, and that's what you need to do. But be sure that you are looking at the legal description. This space may not be big enough. If it's not big enough, then you're going to add it as an attachment. Oh, excuse me. And then what you write in there is like C Appendix B or Exhibit B or Appendix B to put in there, right? If you're not sure about your legal description, please talk to a lawyer. One of the things that A Month of Service has been doing, and hopefully we'll be able to continue this going forward, is that we have had TODD clinics where we assist clients coming in who are doing their own TODD clinic, and there's individuals that are going to be there to help you find your legal description and be able to do that work. So keep an eye out for those clinics in the future. We don't do them every month, but keep an eye out for one of those events in the future. So that way there can be some assistance there. And then number 3 would be the address of the property. So this is where you're going to put 123 8th Street, Houston, 77002, right? Whatever the address is of the property. So, right. So again, so section 1, that's your address, how you can be reached, your mailing address as the owner of the property. And then number 3 is the address of the property that is being handled under the transfer on death deed. They may or may not be the same. Okay. Then we now have our 3 sections. There's a section A, a section B, and a section C. That's the first level of ABC. You are picking one of those. You're picking either A, B, or C. You're going to pick one of them. So it's quite possible that you may have a page where A is on, and then you have a page for B where there's nothing there because you have picked C. You could have an A and then a B and a C where there's going to be nothing there because you picked A, right? So hope you're following. So you're going to pick one of these sections. So for section A, this is when both spouses own the property and you want to leave it to a surviving spouse. You are creating a right of survivorship. That's not the same as creating a joint tenancy with a right of survivorship that I talked about under the will for non-probate asset. But in this case, the TODD is creating a right of survivorship in the spouse, but then the property is going to pass after the spouse passes, right? So in this case, what we're naming is that the first beneficiary, the primary beneficiary, is the surviving spouse. Whoever you're married to is going to inherit the property. And then when both spouses have passed, then it's going to go to the alternate beneficiary. So this is where you're going to list your children, your cousin, like whoever it's going to be. Then you're going to list who's going to get that. One of the things to be aware of is that in this TODD, there is no different percentages. So if you have 2 people there, they're each going to get 50%. You have 3, they're each going to get a third, right? So it's they are like there is no like mathing here. It has to be equally divided. But that's going to be section A. You're married, you want your spouse to inherit the property, and then on the passing of your spouse, then it's going to go to somebody, they're going to be going to the alternate beneficiaries. Very common. This is a very common level, and this may be where you stop because you're married and it's going to go to the children after the passing of the surviving spouse, right? So this is pretty common that you're going to end at A. But if you don't end at A, so this is section B, you're picking one. A doesn't apply. You're not married, or you don't want your spouse to inherit the property, right? Or in this case, you have one spouse who owns the property, right? So this one, both spouses own the property. So you're going to go back to section 1. You're going to have, you and your spouse, Barbara, right? So that's who we got in there. And so section A, you and Barbara, after Barbara passes, is going to go to your children. Okay. And now, in this case, only one spouse owns the property. So you both didn't buy the house. You have a house from a separate that you bought before you were married. So that's your house. That's your separate property. So that's what's going to be here, right? So this one, you're naming your spouse as the primary beneficiary. And their spouse, right? In this case, that's where it actually ends. Okay, so part A is that when Barbara passes, it's going to go to Bob and Susie, the children, right? So that's what's going to happen in 1. For B, you give the house to Barbara. The house belongs to Barbara, right? So you own your house and you give it to Barbara. She now owns the house. And then when she passes, the house is going to pass according to her executed transfer on death deed or her will. Barbara gets the house under 1 as the primary beneficiary. The only time that the alternate beneficiaries get the property under 2 is if Barbara passed beforehand, right? So Barbara has passed, you survive, now you're going to give it to Bob and Susie. But if Barbara survives, Bob and Susie do not inherit upon the death of Barbara. Okay. So that is what's happening in B. Very different from A, right? A has the children will ultimately be the beneficiary. Bob and Susie ultimately own the property. In B, it depends on whether or not Barbara is alive at the time of passing. Okay. And just like under A, equal, if you name two people, Bob and Susie are going to get it 50% each. Right. So for both A and B, you're going to see this transfer on death language. And this is where you're going to decide what happens when people have passed, basically. This is what happens next. Primary beneficiary has passed, alternate beneficiaries, now we're going to decide what to do with the alternate beneficiary. So if the alternate beneficiary is a child or a sibling, you must complete this section. And so, and how does this work? When you're picking A, so again, this gets really confusing. All right, so Barbara has passed. Bob and Susie are inheriting the property now. So what do you want to happen if either or both Bob and Susie have also passed, right? So Susie has passed and Bob has survived. What do you want to happen to that, right? And so if you pick A, it's going to pass to the deceased beneficiary's heirs. So Susie has passed, but she's got two kids. And so those two kids are going to take Susie's 50% and Bob's going to take their 50%, his 50%, right? Or B, no one else. Susie has passed. You don't want it to go to Susie's beneficiaries. That means Bob is going to inherit the property. Okay. And if both of them have passed, there's both have deceased, then the TOD is not valid. Property's not going to pass under the will. Okay. Which is the reason why you always need a will. I didn't say that. I usually say that like 5 times in one of my presentations, regardless of whether or not you're using a transfer on death document. Everyone needs a will. Be sure you have a will. So it's better to not need a will and to have a will and not need it than to need a will and not have it. So everyone needs a will, because as a TOD becomes ineffective, the will govern. All right. Section 3. I will say that for most people, it's either going to be A, they're married and want their spouse to get it and then their children, or it's going to be C. I don't see B's very often. I see mostly A's and mostly C's, because C is everything else, right? You don't have A doesn't apply, B doesn't apply, C is everything else, right? So that's where we're going to be. So again, we're still at this level. We're picking either A, both spouses own the property, and there's going to be a survivorship, and then to the children, or it's going to be B, one spouse owns the property, and it's either going to go to it's going to go to the spouse, but only, and then to children if spouses pass. Right now we have C, our third option. Everything else, if it's not A, you're not married, and you both own the property, it's not property that you own. Now we're going to look at C. We're going to pick C. All right. The spouse is not the primary beneficiary. You can make the spouse beneficiary, but it's not it's not written in that way. So number 1, you're going to list your primary beneficiary, ease, one or more, right? Then you're going to pick your alternate beneficiaries. All right. And this is if the alternate beneficiaries only inherit if all the primary beneficiaries have passed, right? So your primary beneficiary is Bob and Susie. We're going to assume that we're a single person and we have adult children. So Bob and Susie, both Bob and Susie have to pass for the alternate beneficiary to take currently. Now we got sections that we got to fill out, right? So that is how this section is. Or it can be Barbara. You could put Barbara, and then in the event of Barbara's passing, it can be Bob and Susie, right? Oops. All right. Now we have a second set of ABCs. We have our first set where there's a little square next to the ABC. You're going to check that box off. You're picking one, A, B, or C. You're going to check the box off. But under C, You have another set of ABCs that don't have boxes next to them, right? They're just there and they have their own little thing. Under C, you must complete all ABC. If you pick A, you don't fill this out, right? Pick B, you don't fill this out. This is only if you are using section C, and then you're going to complete under section C an A, B, and a C. You're going to do all three. And the best thing I can offer in terms of how to explain this, I'm going to do my best to do it right now. Read the document carefully because it's telling you exactly what you're deciding. But there's different levels depending on what has happened with your primary versus your alternate beneficiary. Okay, so we're going to assume we have Bob and Susie, and Bob and Susie have children. Susie has 2 kids, and Bob has 1 kid. That's what we're going to kind of go forth in explaining this process, right? So you've named Bob and Susie as your primary beneficiary. So what is section A, right? Is if my primary beneficiary is my child or another descendant or my sibling, right? So these are children or siblings, and one of them passes before I do, what do you want to happen? In this case, it will be that the deceased beneficiary will go to their descendants, or it's going to go to the survivor, right? So what that means is, so now we have Bob and Susie. Poor Susie, Susie has died, and she has 2 children. If you pick A under A, because Bob has survived, Susie has not. Susie's 50% will go to her 2 children, and Bob will get his 50% if you pick A. If you pick B, Susie's kids get nothing. Bob gets 100% of the property as the primary beneficiary. So that's what A under A, choice A and B. Susie's deceased children, Susie children inherits. B, only Bob inherits. Okay. Then we go to B. All right. Again, you have to click all of these because all these scenarios can happen, right? So under B is what if no primary beneficiary survives me, right? So both Bob and Susie very sadly have passed before their parent. And so Bob and Susie both passed away. Now what you want to happen to the property? Is it that you want the property to go to their descendants or to your alternate beneficiaries that you listed up here? So, right? So your alternate beneficiaries under the big block C, you had a 1 and a 2, or do you want it to go to their children or their beneficiaries, right? So it's the same. Under B, if you pick A, the children of the Bob and Susie who have passed will inherit. So Susie, as we said, has 2 kids. They're going to get 50%. So they're each going to get 25%. Bob has 1 kid. That kid's going to get 50% because they're now taking Bob's half, right? So it's unequal, right? But that's how that's how it's written. Their shares are going to pass to their descendants. So that's what A is, right? B is you want the people that you listed under C2 to be the beneficiary. So that will be what will happen, right? So Bob and Susie's kids don't inherit, right? If you have Barbara as an alternate beneficiary here, and Barbara's going to get it. Okay. Now C is what happens if the alternate beneficiaries don't survive, right? So, right, you're still going to complete it, right? Because what happens if Bob and Susie didn't have any kids, right? There's no descendant to take, right? And so, or maybe there is, right? So you're going to still do C. So what happens if the alternate beneficiary doesn't survive, right? So that's Barbara, right? So A, same thing. The alternate beneficiaries share. They will get their portion of their heirs will get it, right? So that's going to be the A. And then the B is no one else. You don't want it to go anyone, and the result is that there's no primary beneficiary who survives. There's no alternate beneficiary that survives. Then the TODD is canceled. It no longer has any effect, and the will is going to pass the property is going to pass according to the will rather than under the TODD. Yeah. I know this is very, very confusing. So I'm going to just do a quick summary. There's an A, B, and C with a checkbox in front of them. You're picking one of those. A, if you were married and you want your property to go to your spouse, and upon the death of your spouse, you both own the property, it's going to go to your children. That's A. B, you own the property alone, and then you want your spouse to be the primary beneficiary, but in the event the spouse passes, to the children. That's going to be B. C is everything else. And then under C, you're going to name a primary and alternate. And then under the C, under the first A, you're going to pick whether or not who's going to inherit the property if a primary beneficiary passes. B, if there's no primary beneficiary who survives. And then C, if there's no alternate beneficiary who survives. And for each of those, A is picking the descent that the heirs of the person who's passed is going to get the property. And B is it does not. It's going to either go to the surviving alternate or the surviving primary, or the will or the TOD's going to have no effect if there's no one left. All right, what to do next with the TOD? With the notary present, you must do this with a notary. And if you have a co-owner, you've picked A and there's a co-owner on there, then both of you need to sign it with the notary. And then of course they will sign it, the notary will sign and affects the notary seal. You must record it. What does that mean? You must file it. And that is with the county clerk in the county where the property is located. I am in Houston, I am in Harris County. So my home is in Harris County. I would file mine in Harris County, but I am in Houston, but I live in Pearland, and that's Brazoria County. Then I'm going to file it in Brazoria County. It's where the land is located. You may live in Harris County and you have your own property, but then you have a separate house, a lovely little vacation home, maybe in Galveston. You will file it in Galveston County, where your vacation home is located. All right. It is not effective if it's not filed. So once you send it to the clerk will return the TOD to you with a file stamp on it, and you're going to keep it with your other safe documents, with your will and other advanced planning documents. And then when the time comes, then a notification of death is filed as well with the county clerk, and then that will make the TOD effective. If you change your mind, you must file a new TOD or a revocation. If you want the property to pass according to the will, you must file a revocation. But a new TOD, you decide that, you know what, Barbara's not going to inherit anything. I want everything to go straight to Susie and Bob. Then you're going to just draft a new one and file a new one, and then that automatically voids the one that's already been filed. Okay. Some quickly additional forms. Again, I would recommend you go back to part 1, where I talk more in depth about each of these other documents and what they do and if and when you need them. Statutory forms, what the statutory mean, the folks in Austin have written it for us. We don't have to think about it. They're actually not complicated. And so going through and discussing how to draft it is pretty straightforward, because you're just writing in the names of who you're listing as your person with the power, and then picking your options, and it's again pretty straightforward. But those documents are your statutory durable power of attorney, that is decision making around legal and financial matters in the event of incapacity. A medical power of attorney, that's making decisions on medical decisions in the event of incapacity only. An advanced directive to physicians, commonly known as a living will. This is life whether or not to do life-sustaining treatments or allowing a person to pass in the event of a terminal or irreversible condition. This is not something that happens just automatically. There's always a person involved in the decision making, but it provides the instructions of what you want in the event of either of those situations. A declaration for mental health treatment is also known as a psychiatric advance directive, a PAD. This is for individuals who are at risk for psychiatric hospitalization. Think of people who have schizophrenia as an example. They may get hospitalized, and this is basically them giving instructions on the type of medication and treatment they should have in those situations when they are no longer able to make decisions for themselves. Really, really important document for people that apply to these individuals. There's also some additional forms. They are also very uncomplicated, which is why we don't spend any time doing that. But a declaration for a guardian in the event of later incapacity. This is a situation where a person is permanently incapacitated and a guardianship is needed. You're saying who you want to be your guardian to take care of your physical health as well as your financial and legal matters. And that is what this document is literally 6 sentences long. In that document, you can also say who you wish to not serve in that role. And that can be just as important as naming who you want to serve in that role. Again, I talk in more detail about what the different aspects are in the other presentation, but if you have questions about that today, you can ask. A HIPAA release is allowing people subject to HIPAA, which are typically what most people think of as medical providers, any medical providers. But it also includes lawyers and some other folks that may be subject to HIPAA. We cannot share medical information that we obtain in the course of our work without the express permission of the person whose medical information it belongs to. You want to do a general HIPAA release for your medical power of attorney and the person you name as your guardian of your persons, so that way they can get access to medical information from all of your medical providers, not just the ones that have the individual forms that the hospital or doctor may have had you complete. A supported decision-making document is a really useful document for people who have diminished or diminishing capacity. So it's very useful for children who age up, who are turning 18, where they may need some support in helping make decisions, but it also is very useful for people who are aging, elderly clients and elderly individuals who may have a cognitive decline and need some support. So this is not a decision-making document. The person doesn't have the ability to make decisions on behalf of the person who signed the document, but it is where a person gets called, where it's like, hey, I want this person to have the authority to be able to get information for them to be able to help me make this decision. So a very useful document. And that is it at 2:30. This is a lot. I only talked about how to draft your own documents, and this can be overwhelming. Again, if you have specific needs that are not covered by a pro se will, you really should consider consulting an attorney to help you draft the document, draft the will, so that way your wishes are in effect and are taken care of. The TODD is also pretty confusing. But if you feel like you need assistance and you qualify, you are more than welcome to apply for assistance. That's my information at Lone Star Legal Aid. But we also have other partners. We have Houston Volunteer Lawyers, as well as the Earl Carl Institute, that also assists with advanced planning. And so they are my colleagues, and I think they're fantastic. I'd love it if you called me, but you don't have to call me. And we are able to assist if you are eligible for services. And with that, I like to always end on a joke or a comic, because this is a heavy topic when you're talking about planning for death and incapacity. And so I try to make it a little bit humorous at the end. And so we have a cartoon here where they are standing with their loved one, and it says, "Who cares about where he buried the gold? It's his passwords and other digital assets we need." So yes, you want to be sure that people know how to get to your digital assets. But at this point in time, if you have any questions, feel free to unmute yourself if you're in Zoom, or type it into the chat. And if you're in Zoom, or if you are online, you can put it into the comments there. Again, just as a reminder, I cannot provide legal advice today for anything that's a specific need, but also don't put anything private, personal. Let's not give our stuff out to the world. All right.
I know that you don't generally kind of try to stay away from trust and what have you, but somebody wants to know the difference between the revocable living trust and a will.
They're completely different documents, right? And so a will is in effect when a person passes away, right? So you're going to take the will to the court and do that. There are various reasons where a person will develop it, will create a trust. Um, and a trust is basically doing everything in the front end versus in the back end, right? If you're looking at it from a probate perspective, there's other reasons to have trusts, and those, has it's related to who's inheriting the property, if they have special needs. Sometimes people are creating trusts to become eligible for benefits. So there's a lot of different reasons for that. But I always kind of say, what is the reason behind the trust? If the only reason why you're doing a trust is to avoid probate, you're not actually really avoiding anything. You're just shifting the work, right? You're shifting the work that normally gets handled after a person passes under a probate administration to doing it before. It's all the same thing. And if they're creating a trust to also then just disperse upon the passing, so you're like, I'm creating a trust to avoid probate. Now you've transferred everything into the trust, but the trust says, upon my death, disperse it to my beneficiaries. it's the same process. It's the same work. You're not actually reducing any work. And in fact, you might actually have given yourself more expense because now you've created the trust, done everything to transfer it to the trust, and now the trustee, who is now going to disperse the trust after a person's passed, also now needs to probably potentially hire an attorney to disperse the trust, right? And I say that because when I get questions about trust, it really is like we're trying to avoid probate, and that's usually coming from a national expert talking about probate planning and estate planning. We're in Texas, and when you're listening to a national expert, they're talking about generalities, but there's 50 states, and each state has their own rules when it comes to things. Texas actually's probate process is really pretty simple, if you have a well-drafted, properly executed will. And so it's where, which I kind of covered a bit in the instructions, right? Like in the will, when they're talking about doing it without bond and an independent administration. Like if you remember, if you think back to that, that is only three things that have to happen in court. There's one court hearing, literally just one court hearing. It takes less than 10 minutes. You will probably wait longer to get your case to get called than you will actually talking about your case. But then all the work that happens in terms of selling the house, repairing the house, like all that happens separately. And then there's an inventory that gets filed with the court. You don't go to court to do that. You just send it to the court, right? Like here's the inventory. And that's it, right? So our probate process is pretty simple when you have a really good will that's correctly executed. But like other states, their probate process are much more complicated. And so in that state, estate planning is trust planning. It is creating a trust because the probate process is not simple like it is in Texas. And so I don't say you don't need a trust, but you have to ask a question on why. If the only reason is to avoid probate or to save money, that might not actually be what you've accomplished by doing a trust. But if there's other things, right? Minors inheriting, people living with disability, tax planning. If you're a wealthy person, trusts are used for for tax planning purposes, right? Like so there's other reasons. You're a person that needs to get assets protected so that you can qualify for Medicaid, for long-term care. There's reasons for it. I do recommend you talk to an attorney though. If you're thinking, I do need a trust, talk to an attorney because you want to be sure that you're not actually doing something that's not needed.
Yeah, for sure. Okay, and can you reiterate about if a husband and wife, if a deed is in both the husband and wife's name, do they need to both do separate revocable forms? Or if they choose to make a change or alteration, do they both need two separate ones?
Maybe. So if it's the surviving spouse, so if you're going to be selecting A, you both own the property and you both agree that you want your children to inherit upon the passing of the surviving spouse, then no, you only need the one, right? You only need the one document because you're both going to sign that same TOD, right? But if not, if you're going to pick C, right, you're going to pick C and you're going to have different people inherit your 50% of the property, then yes, you're going to want to have two different um TODs.
So let me ask this. If a couple signs the one TOD initially, and then the other one of the spouse just decides, you know what, I don't know that I think I want all of my share to go to my kids. I don't want it to go to the spouse.
Mhm.
Do they then have to revoke that one together, or does the one spouse then still go and file a separate one and choose C?
You would want both people to do either the revocation or two new TODs, right? So yes, you would want um hopefully no one's doing that without talking to their
I know
partner.
that's how I'm
But
just trying to get that. I'm just
but yes, no, both people would need to do something, right? Because if one spouse files a new TOD and it revokes his portion, but now you run into this issue like what's happening with them. And so yes, you want to, if you're changing your mind and you're not going to pick C, then you both need to do a revocation or
yeah. I'm
Yeah.
just making sure.
Yeah, yeah. I'm like,
Because I
no.
know that that's a question that I'll probably get offline. That I just thought about that.
You're like, oh, there's some other problems there if you
Yeah,
contact
for
your
sure,
spouse.
for sure. And yeah, and no, I'm not your legal counsel, so please don't call me
Yeah,
and
no,
ask
no,
me.
no go beyond that, but yeah.
Yes, so for the person that asked about the recap of the presentation, it is being recorded. I will send out the link of this recording so that you can go back and watch it. The copy of creating the documents about creating your own will and your own TOD, those documents will be included in this when I send out the email too. And it has the instructions and everything there that's in the kit on how to fill it out, even though, so if you want to go back and watch it after you've printed that kit out, then you'll be able to kind of follow along and see what exactly is that she's talking about as you're going through it. I like for her to read it before, I mean, to kind of go over it with you guys beforehand before I send it, because if you're trying to listen and kind of get a grasp and look at the same time, you're reading through and then not really paying attention to what she's saying. So I do that on purpose, and I'll send out the documents afterwards so that you can see exactly what it is that she's talking about, and you'll be able to follow along with those instructions just to kind of give you a little bit of extra assistance as you're looking over the document. So, because otherwise, if you've never seen a tile before, don't know what you're looking at, never seen it, all A, B, and C, married, not married, and then it is thoroughly confusing if you've never seen it before, and have never done any part of that before. So I do that on purpose. So,
I do
and
recommend going back, like if you have access to a computer, which I'm assuming you do because you're watching this online, but and you're comfortable doing it, that link that shows you to do an online interview, the questions are exactly the same. So you can still like watch this again with the forms in front of you, but then go to that online form and then complete it that way. Then what gets printed is exactly what you need, as opposed to you being like, oh wait, do I need to do the C and what like right. So you would go through this process, and then what gets printed is a specific TOD for you. So if you're comfortable being on the computer and doing it that way, that would be the best practice if you can.
and that link will be included as well so that you
Mhm.
guys can go back and do that. So you have the option, print a hard copy or do the online, use the online link that'll create it as you're going through the steps. So again, it's not a like a or like a legal, what do you call those things? Rocket Law or one
Yeah,
of
it's
those.
not.
It's not one of those kinds of websites where you can do the fill in the blank kind of form. This is the state approved
Yeah.
link that they've created for you to actually go in there to create that document. So just know that too. I want to make sure everybody knows that. I don't see any other questions here, and then nothing on social media either.
All right. Well,
So I
fantastic.
think
Thank
that's
you,
about it.
everybody. I appreciate the flexibility on the new date, and y'all know how to get a hold of us if you have any questions.
All right. And then we will be back on the first Thursday of next month, which will be December the 4th,
Mhm.
for part one. If you guys want to hear the live presentation next month, feel free to join us for that. Sometime next week, I will definitely have the the event on the website for you to go in and to register. So we want to thank you all for joining us this afternoon. Again, hope that you received all the information that it is that you needed about the wills and a TOD and how to complete them both. If you do have any questions, please feel free to reach out to myself or to Jesse. The links also for the legal service partners to go to their websites to register and apply for their services will be provided for you as well. So thank y'all. You all have a wonderful remainder of your day. You take care of yourselves and stay safe, and we will see y'all next time. And happy holidays to you in case anybody, not joining us before now and Thanksgiving. So y'all have a good one.